Hi, today I am going to share with you about the principle of per incuriam. So this is a principle where courts may pass orders without applying the principles of law. Now if trial court passes orders without applying the principles of law, it cannot be executed. There could be many instances. For example, in a simple layman terms, I would explain how if the legal principles are not applied and order is passed or a decree is passed by the court, what happens? Imagine a property, an immovable property, wherein a wrong plot number was given, or a wrong boundaries were given, or a wrong survey number was given, or a wrong village was given, or a wrong mandal was given, a wrong district was given. That is, there could be some sort of error in the schedule of the property, or there could be some sort of error in the description of the parties, or there could be some portion of error in the rights of the parties. Whatever may be the case, if there is an error and that is not considered by the court, even though you reported it to the court, especially in the trial courts, then the decree could not be executed. Now what happens when the same thing happens in higher courts? There could be a decision on per incuriam. That is a decision made by the court without taking care. That's a Latin expression. Thorough care was not taken in taking that decision by the court. That will be a decision of per incuriam. If that decision is taken, for example, by High Court, what happens? Nothing to worry here, because the decision of per incuriam cannot be considered as a precedent. That is, generally the decisions of High Courts and Supreme Court, the decisions of higher courts are corrected by the higher courts itself or by a much higher court. That is to say, the wrong decision of the High Court is corrected by the Supreme Court. Sometimes the wrong decisions of Supreme Court are corrected by the Supreme Court itself in a similar two-judge bench or higher bench. Now what happens in a situation where High Court passes a wrong order and the party doesn't prefer an appeal and leave it like that, or makes a compromise with the other party and allows the wrong decision to stay without correcting, because wrong decision can be corrected by filing a review or an appeal. If either the review or nor an appeal, neither the review nor an appeal was filed by the party and the wrong decision stays in the docket of the High Court, then it is a wrong question of law was decided. Now whether it will be applied? No. The answer is no. Either in the trial court or in the higher court, a wrong decision cannot be applied, will not be applied. Law will not permit you. So if a wrong decision is made by the court and if you could not review it or if you could not file an appeal, there is nothing to worry. It cannot be taken forward. It cannot be applied. So this is the principle of per incuriam. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.